Hello. The Divine Code reading for April 16th, pages 627 and 628. We are in the chapter Laws of Saving Oneself or One's Property at the Expense of Another's Money and Taking the Law into One's Own Hands. And for the next several days, the readings will be dealing with taking the law into one's own hands. And this is a preface for this. There's a question, it's sort of an open question regarding the Noahide laws and what we're studying. And the question is, are these laws that are to be used, do we view the current government as being the proper Torah-sanctioned courts of law that exist in today's governments, today's nations and provinces and cities, that we have law courts, we have police, we have systems of justice, we have laws that are established. Do we view these that exist today as the properly sanctioned courts of law, and we are to, within the systems that exist, advocate for the laws to be in line, sort of bring them into line with the Noahide laws, with the 7 laws of the Torah for non-Jews? Or are we to just say, okay, we got these governments, we don't know what to make sense out of them, they're totally off the wall, and we're looking forward to the Messiah, we're looking forward to the temple in Jerusalem, and there'll be a proper court system that'll come down from that, and the current systems are just going to be pushed aside. So the question is, are we working with what we have today, or are we not working with what we have today, but looking forward to something in the future? So the whole question of taking the law into our own hands. The laws that we're getting ready to go into, if we were to institute this is like probably one of the first areas, well, besides the areas of self-defense and protecting another person that we learned about in the laws of murder. This, which, I mean, pretty much most societies would understand that. This area would go directly in the area we're getting ready to go into for the next few days to study, will directly be in conflict with what's called the laws of the land. The laws of the land is what happens to exist in today's governments. And therefore, we have to be very careful, because this is saying we have permission to take laws into our own hands, and that if that comes into conflict with governments, we cannot do something based simply upon we're told we're allowed to do it. Now, if we do something like this, assuming that this is proper, and there's some questions in some of the areas as to whether or not this is actually the Torah law, but if we follow this, even if it's the Torah law and we follow it, and we're coming in conflict with the governments, and it's not an area where we're allowed to defy the law, which would be like in the area of the prohibition of murder, we're not allowed to follow a law that would require us to murder another person. But this is in the area of theft, which is not as strict in this regard. And the question is, would we be allowed to follow this and ignore the police structure that, if we're in a case where someone takes something from us, would we be allowed to follow the permissions as they're stated here to go and get our item back? Or would we be required to petition the government to get to take care of it? And that's an open question that I'm putting out there. It's an important question, and just wanted to preface the part we're going into now with this. Topic number 5. If one is the victim of theft, he may forcibly take the law into his hands and take back his belongings that were stolen, and he is not considered a thief for doing so. Shokanor Koshan Mishpat, chapter 4, and C. Ha'amelech, Amalek, Sha'aliah, 2, 3, which states that only a Jew is allowed to take the law into his own hands in this manner, but not a Gentile, who in doing so transgresses the prohibition of both theft and establishment of judicial systems. So according to the Shulchan Aruch Kosher Mishpat, we're allowed to, or it does maybe it doesn't actually specify whether it's a Jew or Gentile, but the law, the Kosher Mishpat is specifically written for a Jewish audience, and in there it would state that a person may, on his own, go and obtain the item that belonged to him. And then this other commentary is stating that that applies to a Jew, but not a Gentile. And if a Gentile were to do this, it would he would be transgressing the laws of theft. He's going and taking something that is in someone else's hands, and the establishment of judicial systems, which is the courts. And this one commentary is stating that by taking it into his own hands, he is going against the non-Jewish mitzvah of establishing courts of law. This ruling does not seem correct. So the Divine Code, the author of the Divine Code, is disagreeing with the idea that for a non-Jew to take his item back from the thief would be in a violation of the non-Jewish mitzvahs, the Torah laws for non-Jews. The Divine Code disagrees with that idea. Since there is no logical reason or differentiation between a Jew and a Gentile in this manner, despite the reasoning that the law was only enacted after the Torah was given. So, if I'm going to read this logic literally, it would imply that that this is a rabbinic enactment that was given later, allowing the Jew to take his item back from the thief. And we would have to go into the logical reasoning for the rabbis to say that this is possible, and then see if it applies within a non-Jewish system. And then there's a question of whether or not we can use this rabbinic enactment to justify the possible conflict with the requirement to establish courts of law to work with the government in these matters. So the Divine Code is going towards the allowance for non-Jews to take back their property. It appears that a Gentile may also steal back what is his, see Minhag Chinuch, Commandment 224, and even forcibly, providing he does not strike the thief if he is Jewish. So the non-Jew can even forcibly, according to the Minhag Chinuch Commandment 224, which is a more in-depth version of the Sefer HaChinuch, he may take back the possession and even strike the victim. However, because he's not allowed to strike a Jew, therefore, if the thief was a Jew, he would not be allowed to strike the Jew. Otherwise, if the thief is a Gentile, a non-Jew, then he's allowed to strike the thief to take back his item. And apparently, he could take back the item if the thief is a Jew. He just can't strike the Jew. Subject to the restrictions in the next topic. So this will be discussed more later today, and this is it's a lot of moving parts and it's complicated. So we have to make sure we're keeping track of everything. Rather, he is merely saving his own property. So the victim of the theft is allowed to save his property from the thief, assuming it meets the criteria of the next section, the next topic. Therefore, if the thief does not allow the owner to reclaim his stolen item, the owner can strike the thief until he allows the owner to take it back. If the owner has no other recourse. So the owner, okay, so this is a theft. This would be after the fact. If it was a case of the person being mugged, or a case of robbery where the person is strong arming the victim to take his property, apparently at that point the victim can defend himself, because the robber is a pursuer that we assume would be willing to kill the victim to take the item if it came to it. Therefore, the victim can defend himself against the robber with whatever means necessary to defend himself. In the case of theft, the robber the thief has already taken the item. He has it back. He has it in his own possession. The thief has it in the thief's possession, and the victim is trying to get it back. So then the victim is allowed to go to the thief and take the item back that belongs to him, the property that belongs to him, that belongs to the owner, and if necessary, can have a struggle with the thief and can strike the thief. Now, what's not stated here is how much he can strike the thief. I mean, does he slap the guy upside the head, or does he take out a gun and shoot the thief? It's not clear to what extent he can push the his allowance to strike the thief. Although it's probably in the rabbinic writing somewhere. I haven't. Um, he has to be careful to make sure that he's not going beyond what he's allowed to do. The owner is not required to take the thief to court in order to demand the stolen item. Since a thief may use any means since a person may use any means necessary other than serious injury or murder. So it's the threshold of the owner, the victim of the victim of theft cannot kill the thief to get his item back. And he cannot do serious injury. So depending on how we define serious injury, loss of limb would be considered serious injury. But where that threshold is would have to be clearly defined. And I would suggest that to a large extent this is theoretical rather than practical halakas at this point. Although it might have practical implications, but it's in most societies, a person should get the police involved when that works. But this is more theoretical at this point. At least that's just the way I read it. To recover a stolen item that is still intact. So assuming that it's an item that has not been changed, it's still the item that was taken from the victim, and it's something that should be returned to the victim. If it changed its essence, if it used to be a plank of wood and that was turned into a chair in such a way that the chair cannot be turned back into a plank of wood, then it's changed its essence and the victim cannot reclaim the wood if it's not the same thing that it was before. But assuming it's still intact, then that's when the victim can go to reclaim his property. Even if this would require no extra effort on his part, he does not need to bring the matter to court, and he is permitted to settle it on his own. So even if it would be just as easy to call the police, it would be just as easy to The courts, it's a society where it's easy to get into court, and it's easy to see a judge, and it's easy to talk to the police. He is allowed to do this on his own, is the way it's being explained here. However, the owner should not go secretly to steal the object back from the thief unless he has no other recourse, since he will be acting like a thief. And Shokanor Karav, Laws of Robbery, topic 28, and Piti Teshuva Kosher Mishpat 348:1. So we should not, this is a general thing, we should not behave in a manner similar to a thief. We should do things in an open manner. This is just a normal thing in society in general. Like if something belongs to us, we don't go stealthily to get it because it looks, first of all, it looks like the person's acting like a thief. It looks bad. And the other thing, it gets the individual used to the idea of acting like a thief, which can make it easier for the person to become a thief. If they've already gone down that path, even for their own property, it makes it easier to go down that path for someone else's property. So it's not a good idea to do it in a stealth manner, unless there's no other way to get the item back. It would be better to knock on the door, walk in, and just take his item back in front of the thief. That way he's not acting like a thief. The victim is not acting like a thief. In any case in which a person is allowed to recover his own belongings, he is permitted to send another person to recover the object for him. And see Rima Kosher Mishpat, chapter 4, and Mordecai Bava Kama 10, 193, that at the onset, it is forbidden for a Jew to extract judgment through a Gentile individual or court. So there's a ruling that a Jewish person is not allowed to go to a Gentile court unless it's necessary to do so, because it isn't, the Jew should rely upon his own courts, and he should not rely upon a policeman. He should rely upon, this might be where this idea comes from to begin with, that a person should be allowed to do this without going to the courts, and take the law into his own hands, might be a response to the to Gullus, to the exile situation the Jewish people are in which case it would be highly questionable if this would apply to non-Jews. But here we're seeing it seems forbidden only because the obligation of a Jew to specifically seek judgment through the rulings and arbitration of a reliable Orthodox Jewish court, if possible. Therefore, it seems that a Gentile may recover his belongings, enact judgment for himself through others. And then it comes into question of whether or not a Gentile can designate someone as his agent, as a shliach. That's a whole other question. But the argument here is that if a person can do something on his own, if a person can take the object on his own, then he can send somebody else to take the object on his behalf. He can hire a collection agent to go and get it. In fact, if he's dealing with a thief, it might be best to hire a collection agent to do it. But yeah. Topic number 6. This only applies. So what was talked about so far in today's reading, that a person can go and get his own property back. This only applies if the owner can prove his ownership of the item in court. So we're assuming that the owner, if he goes to court, he would be able to prove that the item belongs to him. He has his engraving instrument. He engraved his name in the back of the object or something. There's some way that he can prove in a court system that the object belongs to him. Now, I would open up a question: does this mean that he has to do it before or after he goes and gets the object back? That's. But apparently, it's a provisional thing that if there's a challenge to him taking it, he's going to have to be able to have the proof that it belongs to him. Because otherwise, it opens up a whole can of worms. What if the thief says, "Hey, that belongs to me"? Then the owner, could actually wind up being arrested for theft himself, and that's a serious matter. If he cannot prove this, he may not seize the item from the thief, and he may definitely not strike the thief. In this case, the owner would be liable to punishment by the court if he strikes the thief. And not only is he liable to punishment in the court if he strikes the thief, he would also be liable in the court because striking the thief, that's a minor violation. But the more serious violation is that he might be liable in court for theft, which is a death penalty. He's really putting himself out on a limb. Now, for the Jew, theft does not involve the death penalty. So maybe within the Jewish law, this rabbinic edict that we're depending upon for this section is also dependent upon it being a more lenient sentence for theft versus the non-Jewish capital punishment for theft, which may invalidate this whole section. If even after the fact, if the owner seizing the unproven belongings, his action would be futile if the thief takes the case to court, because the court will confiscate it from the owner who seized it and return it to the thief. So this is the scenario that gets brought here. If the owner, and this is another, there's a proverb that every case seems correct until the other person comes to every person's position seems correct until the other person comes to argue against it. So the thief, in his mind, he thinks he knows he owns the item. He knows that that's his item. Therefore, to him, it's not difficult in his own mind to prove it's his item. And that makes it easy for him to go and take the item back. Well, of course, he knows it's his item. Of course, he can prove it in court. However, if the thief takes him to court and says it's his item, and the court looks at the evidence and says there's no way that the owner can claim, the victim of the theft can claim it's his item, then it's impossible for the owner to make that judgment call on his own that he's going to be able to take the item back. The owner can only take back the item, can take back and retain his unproven stolen item if he does this secretly, so he could deny that the matter ever happened. So now we're creating a new scenario where the owner stealthily, he knows the owner knows it's his. Now the thief could prove in court that it can show in court that it belongs to him, to the second person, the thief. He could prove it belongs to him. So the person is convinced in his own mind that he because it cannot be proven in court that it's his, he decides to stealthily get into the thief's warehouse and take back his item. And then if he's confronted about the break-in at the warehouse, the thieves' warehouse, the owner would deny being involved. And that really goes down the rabbit hole ways. And I'm not convinced on this at all. But this is how it's being presented. It needs more. I'm not saying it's wrong. but I'm saying that it needs more explanation before it's just placed out there as something we're to take as an axiom that we can go and take this property back like in this manner. Simirit Eliam Koshan Mishpat 4.2 and Shokanor Karav Laws of Robbery, topic 29. Rabbi Zalman Nehemiah Goldberg comments that it appears it would be permitted for the victim to steal back his own object secretly, even if he cannot prove his ownership, based on Nevi'at chapter 4 and Pieti Teshuva Koshan Mishpat 4, 1, and 5. Topic number 7. It is permissible for a victim of theft to steal another item of similar value from the thief, even if the original stolen item is not intact or recoverable anymore, in which case the thief would be liable to pay back the value of the money or a similar item as explained in chapter 2. So if the victim, if an object is stolen from the victim and the thief has the object, he still has the object, and nothing's been changed to the object. It hasn't changed its essence. Maybe a provisional change was made, but it can be moved. It could use which case it can be turned back into the original item. But if an actual physical change occurred to the item that cannot be changed back, then it's a permanent change. It changes its name is the terminology used, and in which case, or if it's eaten, the person stole a bushel of apples and the apples have rotten to the point where they're no longer apples, or they're turned into applesauce, so they're no longer apples. They're applesauce, and they cannot be turned back into apples, or the apples rotted, or the apples were eaten. In any of those cases, they're no longer. You can't give them back to the owner as a bushel of apples, and so the thief owes the owner the value of the bushel of apples. He has to pay money for the bushel of apples. So in that case, the victim would be allowed to take something as collateral. No, the victim is not. Yeah, that'll be later explained as such. But at this point, the victim would not be allowed to take a different bushel of apples or a bushel of oranges or whatever of similar value and just take it on his own and say, okay, I am reimbursing myself. If the bushel of apples is there, from what we learned in the last couple topics, the victim would be allowed to take back his bushel of apples, but he cannot take back something else of similar value, even if it's a different bushel of apples. He can't take that back and say, okay, I'm taking this back as for my property. Even if the original stolen item is not intact or recoverable anymore, in which case the thief would be liable. Okay, this is because it is forbidden to steal the thief's personal items. So that different bushel of apples, as far as we can tell, belongs to the thief. So we're not allowed to steal an item that belongs to another person, to the thief. We can only take back the item that belonged to the victim, but not a different item which would be said to be belong to the thief. Instead, the victim should demand compensation in court if he is not able or willing to take back his stolen item on his own. So if he doesn't feel confident, the way it's being presented in the Divine Code is that the victim of the thief should initially take back the item on his own. If he is not able to take back on the item on his own, then he turns to the court, either to give back the item, to take the item back for him, or to take back the value of the item, to compensate him for damages of the loss of the item. So in the way it's being described in the Divine Code is that the court is the backup system to the victim doing it on his own. Shokunor Karav, Laws of Robbery, topic 27. It appears that this is not a Torah prohibition, as will be explained in topic 10, and that's tomorrow's reading. Once a thief has stolen, all his possessions are on lien for his debt to the victim of the theft. And this is being used. This idea of lien is being explained here as something that will be instituted by the court. It's the footnote is attached to the idea of going to court. So the court could demand that he reimburses if he doesn't have money available. The court can demand that he reimburses the victim of the theft with another bushel of apples. But the victim of theft could not go and take that other bushel of apples on his own. He would need the court to institute that. It is nevertheless permitted for the victim to seize money from the thief equal to but not more than the value of the stolen item, since the thief is obligated to give him restitution in this amount. So the thief could not take another bushel of apples. But if there's a cash till there, the victim of the theft could take, let's say the bushel of apples cost $20. He could take $20 out of the till and say, I'm reimbursing myself for the bushel of apples that the thief stole. And he's taking the $20 out. He's doing it openly, supposedly openly, or maybe even stealthily. It's not clear here. He's taken the $20 out to reimburse himself for the bushel of apples. He couldn't take the bushel of another bushel of apples because that's property. But the money is considered taking, and the footnote, taking the monetary value of one stolen item is like taking back the stolen item itself. See She'el Mashev, edition 3, volume 1, chapter 371, Responsa of Rav Pialam, volume 3, and Koshan Mishpat, chapter 5. So taking back the value, the monetary value, would be like taking back the item itself. It's not like it wouldn't be taking back another bushel of apples is not considered like, but taking the monetary value would be considered like. Therefore, we'd be permitted to do so. And in such cases, the victim may take the law into his own hands. So either taking back the object itself or taking the money of the value of the object would be allowed for the victim to do that himself. This does not only apply to the victim of theft, who may steal back his item from the thief. Even one who rents out an item and is not paid the rental fee, or if he was hired for a job and he is not paid, or if he gives a loan and the borrower does not wish to repay. See Rima Koshan Mishpat, chapter 4, in the name of Ridvash. According to the agreed stipulations, then the victim of non-payment, he may seize any money owed to him in the same way as a victim of theft. In all these cases, the person may take the law into his own hands. Okay, so in all these cases, so if the person takes the bushel of apples, what if the person had the bushel of apples delivered to him but did not pay for the bushel of apples? or some other contract, some kind, there's some kind of contracted work, and the person does not reimburse what he owes. In all these cases, the victim can just go in and take the monetary value from the person who cheated him, or who took from him. I would strongly recommend in these areas that there be a clear guideline established. If we're going to say that this is allowed, then governments should have a clear guideline as to how this goes about. For example, it's in the United States, if someone borrows money to buy a car, or borrows money to buy a house, there's usually the house or the car has a lien on it for the monetary value of the loan. And if the person does not pay the loan, then the house or the car is taken by the lender. And this is all spelled out in the contract. It's not done willy-nilly. It's done in a clearly written out contract. So perhaps that's what's being discussed in this today's reading. If it's not done in a clear system, then we're going to have chaos and anarchy and people taking the law into their own hands. There needs to be a system that the person is following when they do this. And if they don't have a system set up, it opens up to all sorts of difficulties regarding the laws of the requirement to have courts of law. So the courts of law have to institute policies, clear policies on how any of this would be done. Otherwise, we can't just do it on our own. So this entire section kind of belongs in the part on establishing courts of law, as much as and then it can be referred to in the laws of theft, but it really needs to be part of the establishment of courts of law. Thank you.